Immigration detention is the policy of holding individuals suspected of visa violations, illegal entry or unauthorized arrival, and those subject to deportation and removal in detention until a decision is made by immigration authorities to grant a visa and release them into the community, or to repatriate them to the country of departure. Mandatory detention is the practice of compulsorily detaining or imprisoning people seeking political asylum, or who are considered to be illegal immigrants or unauthorized arrivals into a country. Some countries have set a maximum period of detention, while others permit indefinite detention. America, United States. In the United States, a similar practice began in the early 1980s with Haitians and Cubans detained at Guantanamo Bay, and other groups such as Chinese in jails and detention centers on the mainland. The practice was made mandatory by legislation passed in 1996 in response to the Oklahoma City bombing, and has come under criticism from organizations such as Amnesty International, Human Rights Watch, Human Rights First, all of whom have released major studies of the subject, and the ACLU. About 31,000 non-citizens are held in immigration detention on any given day, including children, in over 200 detention centers, jails, and prisons nationwide. One of the most recent facilities to open is the T. Don Hutter Residential Center, which opened in 2006 specifically to house non-criminal families. There are other significant facilities in Elizabeth, New Jersey, Oakdale, Louisiana, Florence, Arizona, Miami, Florida, Seattle, York, Pennsylvania, Batavia, New York, Aguadilla, Puerto Rico, and all along the Texas-Mexico border. About 104 mostly young individuals have died in detention of the United States Immigration and Customs Enforcement shortly afterwards during the 5 years between 2003 and 2008, and medical neglect may have contributed to 30 of those deaths. On the 6th of August 2008, 34-year-old New Yorker Hiu Louis Eng died in the detention of United States Immigration and Customs Enforcement. The editors of the New York Times condemned the death and urged that the system must be fixed. The Immigration and Customs Enforcement has stated that the number of deaths per capita in detention is dramatically lower for ICE detainees than for U.S. prison and jail populations, that they provide the best possible health care, and that the nation as a whole is experiencing severe shortages of qualified health professionals. In May 2008, Congress began considering a bill to set new standards for immigrant detainee health care. In 2009, the Obama administration pledged to overhaul the current immigration detention system and transform it into one that is less punitive and subject to greater federal oversight. Immigrants' rights advocates, however, have expressed concern that these reform efforts have been undermined by the agency's continued over-reliance on penal incarceration practices and by the pervasive anti-reform culture at local ICE field offices. Asia-Pacific. Several Asian nations are known to imprison immigrants on visa violations or for alleged trafficking, including the victims of trafficking and smuggling. These include Singapore, Malaysia, and Indonesia. Australia. In Australia, mandatory immigration detention was adopted in 1992 for all non-citizens who arrive in Australia without a visa. That only border applicants are subject to detention has sparked criticism, as it is claimed to unfairly discriminate against certain migrants. Other unlawful non-citizens, such as those that overstayed their visa visas, are generally granted bridging visas while their applications are processed, and are therefore free to move around the community. The long-term detention of immigrant children has also sparked criticism of the practice by citizens groups such as Chill Out and human rights organizations. Nonetheless, the High Court of Australia has confirmed by majority the constitutionality of indefinite mandatory detention of aliens. This and related decisions have been the subject of considerable academic critique. Australia has also subcontracted with other nations to detain would-be immigrants offshore, including Indonesia, Papua New Guinea, and Nauru. Australia also maintains an offshore detention facility on Christmas Island. In July 2008, the Australian government announced it was ending its policy of automatic detention for asylum seekers who arrive in the country without visas. However, by September 2012, offshore detention was reinstated. Following the Australian federal election, 2013 policies have been toughened and Operation Sovereign Borders has been launched. Japan 3 main detention centers, Higashi Nippon Nukoku Kanri Center capacity, Ushiku's Ibaraki, Nishi Nippon Nukoku Kanri Center Ibaraki, Osaka. Omura Nukoku Kanri Center capacity, Omura, Nagasaki, Europe. Italy. In Italy, the situation is mostly the same as in the Netherlands. Illegal immigrants are sent to CIE if they don't have their document. Illegal entry and stay on the Italian territory became a criminal offense in 2009, after the Bossi-Fini law, since they have the function of allowing confirm the identity of the persons held in view of a possible expulsion, or to hold persons awaiting expulsion to some the sense of political track in relation to the legislative apparatus in its immigration entirety. It has been reported by many NGOs that the condition inside the centers are inhuman. Amnesty International denounced that the immigrants are placed in containers and in other types of inadequate housing in an extended stay, exposed to extreme temperatures, under conditions of overcrowding. Malta. In 2002 and the following years, Malta began to receive a large influx of migrants. The government then began to apply the 1970 Chapter 217 of the Laws of Malta, providing for detention for all prohibited migrants, including prospective asylum seekers, soon after apprehension by the immigration authorities. In 2003, the Maltese government substituted the indefinite detention policy with an 18-month detention length, after which the applicant is transferred to an open center if the processing of his/her application has not been finished. The Maltese detention policy, the strictest in Europe, gathered heavy criticism by the UNHCR for the extensive duration of detention, and in 2004 it was also criticized by the Commissioner for Human Rights of Council of Europe, Alvaro Gil Robles, as international standards required cautious and individual examination of each case and proper legal checks before incarceration, which were missing in the Maltese legislation. The Council of Europe also criticized 4 of the administrative detention centers as in deplorable conditions and failing to live up to legally binding international standards. The Ministry for Justice and Home Affairs pursued the migrants' detention policy nevertheless, justifying it in 2005 by national interest, and more specifically for reasons concerning employment, accommodation and maintenance of public order. In 2008, an EPOIM comparative study found that, following a long stay in detention, are then released into the community, joining the black market economy and suffering abuse with regard to conditions of work. The detention policy was criticized in the following years by NGOs and international bodies, including Human Rights Watch, the Jesuits and UNHCR. In 2012, The Council of Europe reiterated that such a policy is contrary to the prohibition of arbitrary detention in the European Convention on Human Rights. Netherlands. In the Netherlands, foreigners who fail to obtain a residence status can be detained prior to deportation, as to prevent them from avoiding deportation. Detention centers are located in Zaandam, Zeist, and Alphen aan den Rijn. Besides these detention centers, there are deportation centers in Schiphol and Rotterdam. Immigration detention in the Netherlands is criticized for the circumstances immigrants are held in, which is often worse than that of criminal detainees, especially because of the lack of probationary leave, rehabilitation assistance, legal assistance, laws restricting the maximum detention time and a maximum time for judicial review from a judge. Portugal. In Portugal, the Ministry of Interior is responsible for immigration matters. The country currently has one officially designated immigration detention center, located in Porto. Opened in 2006, the center is managed by the Luke Immigration and Border Service. Unidade Habitacional de Santo Antonio. There are also 5 centros de instalação temporária located in each major airport: Porto, Lisbon, Faro, Funchal and Ponta Delgada. Besides this government-led places, in Lisbon there are the Bobadilla Reception Center for Asylum Seekers run by the CPR and the Pedro Arape Reception Center managed by the Jesuit Refugee Service. Ukraine. In Ukraine, temporary detention centers are run by the State Border Guard Service of Ukraine, responsible to the President Pavshino. United Kingdom. The British Home Office has a number of detention centres, including, as of January 2015, 11 designated immigration removal centres, 4 designated residential and short-term holding facilities and 1 non-residential short-term holding facility. 4 of the IRCs are managed by the prison service and the others are outsourced to private companies including Mighty, Ggia Group, G4S and Serco. People can be detained under Immigration Act powers for a number of reasons. The largest category of detainees is people who have claimed asylum. Other people include those detained awaiting determination of the right to entry to the UK, people who have been refused permission to enter and are awaiting removal, people who have overstayed the expiry of the visas or have not complied with the visa terms, and people lacking the required documentation to live in the UK. The Nationality, Immigration and Asylum Act 2002 formally changed the name of detention centres to removal centres. The centres are Campsfield House in Oxfordshire run by Mighty Group, Brook House near Gatwick Airport which is run by G4S Group, Colnbrook Immigration Removal Centre near Heathrow which is run by Serco, Dover Immigration Removal Centre which is run by the Her Majesty's Prison Service, Dungavel in Lanarkshire run by G4S Group, Harmondsworth Immigration Removal Centre also near Heathrow which is run by Ggia Group, Haslar Immigration Removal Centre which is run by the Her Majesty's Prison Service, Larne House, Larne Antrim which is run by Reliance Secure Task Management, Lindholm Prison near Doncaster which is run by the Her Majesty's Prison Service, Moreton Hall Immigration Removal Centre near Newark which is run by the Her Majesty's Prison Service, Pennine House at Manchester Airport which is run by the Reliance Secure Task Management, Tinsley House near Gatwick Airport which is run by Global Solutions Limited, The Verne on the Isle of Portland which is run by Her Majesty's Prison Service. Yarl's Wood Immigration Removal Centre in Bedfordshire run by Serco. The former Oakington Immigration Reception Centre near Cambridge was closed in November 2010. Additionally, some prisons detain migrants or asylum seekers purely under Immigration Act powers, usually if they have been serving a prison sentence which has expired. There are also 4 short-term holding facilities in Manchester, Dover, Harwich and Colnbrook. The British government has been given powers to detain asylum seekers and migrants at any stage of the asylum process. The use of asylum has increased with the introduction of the process of fast track, or the procedure by which the Immigration Service assess asylum claims which are capable of being decided quickly. Fast tracking takes place in Oakington Reception Centre, Harmondsworth and Yarl's Wood. There are 3 situations in which it is lawful to detain an asylum seeker or migrant. To fast-track the claim, if the government has reasonable grounds to believe that the asylum seeker or migrant will abscond or not abide by the conditions of entry, if the asylum seeker or migrant is about to be deported. Figures published for January to March 2008 by the Home Office revealed the following: 2,305 people were detained in removal centres in the UK under Immigration Act powers. 1980 immigration detainees were male. 35 children under 18 were detained. 1640 detainees had claimed asylum at some stage. Once detained, it is possible to apply for bail. It is preferable but not necessary to provide a surety, and conditions will be provided, usually reporting, if bail is granted. There is legal aid for representation at bail hearings, and the organisation Bail for Immigration Detainees provides help and assistance for those subject to detention to represent themselves. Since summer 2005, there has been an increase in the detention of foreign nationals since the Charles Clark scandal, which revealed that there were a number of foreign nationals who had committed crimes and had not been deported at the end of the sentence. Criticism of immigration detention focuses on comparisons with prison conditions in which persons are kept though they have never been convicted of a crime, the lack of judicial oversight, and on the lengthy bureaucratic delays that often prevent a person from being released, particularly when there is no evidence that the detainee will present a harm or a burden to society if allowed to remain at large while their situation is examined. Recently, the conditions of detention centres have been criticised by the United Kingdom Inspector of Prisons. The Tinsley model in 1996 Immigration Detention Centre, Tinsley House, was commissioned. It was the first purpose-built immigration detention facility in the United Kingdom and was initially managed by the British subsidiary of the American Wackenhut Corporation. The original senior management of Tinsley House, specifically the centre director and its operations manager, pioneered an adapted version of Wackenhut's philosophy of dynamic security, which promoted a regime of caring custody emphasizing positive relations between staff and detainees and encouraging the respectful and sensitive handling of all detainee-related issues. This concerned approach towards detainee management was quickly embraced by the centre's chaplain, who reinforced the existing commitment to caring custody through the creation of specialized training programs for the centre's staff and by increasing the size and diversity of the centre's chaplaincy team. With the active support of the centre's senior management, the Tinsley House chaplaincy set about the task of addressing in detail the dietary, cultural, religious and social needs of the centre's population, inviting a variety of religious ministers and representatives of cultural groups to attend the centre to provide pastoral support. Tinsley House became the first detention centre in the United Kingdom to operate a comprehensive regime regime of religious and cultural observance and to operate a diversity of permanent religious facilities. The attention to religious and cultural needs combined with an overt commitment on the part of the detention center staff towards treating those in the custody with care and sensitivity began to impact the environment and operations at Tinsley House. Detainees would write messages of appreciation to members of staff noting their efforts of assistance, and staff would regularly form respectful friendships with those in the charge. The product of this regime, which became known as the Tinsley model, was to result in an environment which, during its first decade of operations, incurred no incidents of death, riot or disturbance, a performance never before achieved in the history of the UK Immigration Service. The Tinsley model attracted the attention of HRH, the Prince of Wales, as well as numerous religious and political leaders, and was cited as being a graphic example of the effectiveness of caring custody. In December 2001, the senior chaplain of Tinsley House authored a report to the Home Secretary detailing the essence of the Tinsley model, recording its positive effects and outlining how this regime might be exported throughout the immigration estate. The report was signed by 16 bishops, 4 leading Muslim clerics, representatives of the Sikh and Hindu communities, 4 members of the House of Lords, and the Member of Parliament for Crawley. The Home Office response to this proposal was to pass it to the Immigration Minister, who forwarded it to the head of the Immigration Service, who in turn requested that it be actioned by the director responsible for detention operations. The Detention Operations Department of the Immigration Service did not accept the findings of the report and expressed the displeasure at the center's operating company interfering in government policy issues, and which resulted in the suspension of the center's senior chaplain. A month after this report was published, the newest facility in the immigration estate, the £40 million Yarl's Wood Detention Centre near Bedford, was largely destroyed by fire as a result of altercations between staff and detainees, with a lack of support from the Immigration Service, the introduction of Group 4's management style, and a departure of the centre's original management team. The Tinsley model became increasingly difficult to maintain, resulting in a decline in the centre's previously caring regime. In 2009, an unannounced inspection of Tinsley House by HM Chief Inspector of Prisons reported that conditions had generally deteriorated and the arrangements for children and single women were now wholly unacceptable, and that staff talked openly about an increased prison culture encroaching on Tinsley House's previously relaxed atmosphere. The gradual erosion of the centre's initial regime of caring custody effectively marked the end of the Tinsley model, and with it the dynamic of the chaplaincy's intensive pastoral care, which had been a fundamental feature of the model. Deaths in immigration custody. There have been more than 20 deaths in UK detention centres, including Amir Seamant of the 17th of February 2016 Colnbrook Detention Centre, Tahir Mahmood the 26th of July 2013 Dungavel Detention Centre, Khalid Shahzad the 30th of March 2013 Colnbrook Detention Centre, Alois Forzak the 10th of February 2013 Harmondsworth Detention Centre, Kwabena Fosu the 30th of October 2012 Harmondsworth Detention Centre, Brian Dalrymple the 31st of July 2012 Colnbrook Detention Centre, Janos Dragatan the 2nd of August 2011 Campsfield Detention Centre, Mohammed Shuket the 2nd of July 2011 Colnbrook Detention Centre, Eliad Nulin Jens the 15th of April 2010 Oakington Detention Centre, Bereket Johannes the 19th of January 2006 Harmondsworth Detention Centre, Manuel Bravo the 15th of September 2005 Yarl's Wood Detention Centre, Ramas and Kamluka, the 27th of June 2005, Campsfield Detention Center. Kenny Peter, the 7th of November 2004, Colnbrook Detention Center. Tran Quang Tung, the 23rd of July 2004, Dungavel Detention Center. Sergei Barnik, the 19th of July 2004, Harmonsworth Detention Center. Kubaya Dimu Kubija, the 1st of May 2004, Hasla Detention Center. Olga Blaskovica, the 7th of May 2003, Harmonsworth Detention Center. Mikhail Bognarchuk, the 31st of January 2003, Hasla Detention Center. Robertas Grabis, the 24th of January 2000, Harmonsworth Detention Center. Kim Hansen, the 15th of June 1990, Harmonsworth Detention Center. Sihoi Guveni, the 8th of October 1989, Harmonsworth Detention Center. Deaths in immigration custody.